Here is People versus Dunham. The appeal was decided on here, and we're showing the court opinion on that appeal. Here, that appeal was for a trial court opinion made probably not too long before then. I'm guessing 2018-ish. I've been wanting to do a video about this, what's going on here, for years, and I think it's finally time, the right time, and this happened to cross my mind again recently. We're going to cover it. There's a man, as far as I know, from when I most recently checked, over a year ago, and I think an appeal was actually attempted again, trying a different angle, and didn't hold up. That was 2024. Now this is being recorded in November of 2025. As far as I know, still, or as I'm slightly speculating, but probably he's still in prison, New York State. There's a man by the name of Todd W. Dunham. He's sitting in there, sentenced. Well over 10-year sentence. Sexual crimes. Is he guilty properly? We're going to take a look at this interesting case. Now, when I originally came across this case years ago, I was able to look at this appellate court opinion, and I believe I also found the trial court. I think I also found that distinctly as well. The trial court opinion states much of the same, but actually presents slightly more details on things that kind of do matter. I can't find that trial court publication anywhere now that's easily available, but like by Google. But it's worth to try to find that. In the meantime, we'll still have this appellate court opinion, which covers much and probably close to most of what all the relevant details would be for us to do our, so to speak, independent or even sovereign assessment of whether true substantive justice was actually effectuated here and carried out. We'll start by reading this. Once we come through this and we've come to understand the entire case as well as it can be reconstructed practically from the details provided by this appellate court opinion that was published. If we could somehow get the trial court opinion, that I believe almost certain that I did see that as a distinct thing, which had different and more details on some things regarding this. We'll try to get that. Otherwise, if not, it might not be fatal to the legal analysis that we want to do here anyway. We'll see why I took an interest in this case. People versus Dunham. This is decided on May 2nd of 2019 by the Appellate Division in New York, 3rd Department. Skimming on. Todd Dunham was the appellant, someone who, as a side note, was sentenced by the trial court. And just so you know, before we proceed here, this was someone who actually had a publication come out after the trial court decision was made, because I'm not the only one who noticed this and found the decision to be somewhat, it strikes at the heart of someone who reads this, okay, and you'll see why. Okay, so this actually ended up in a paper somewhere, right? They did an article about this. Let's skim on here and continue. Memorandum in order. The appeal is made from a judgment of the County Court of Essex County in New York State, rendered, that's right, it was in April, as shown, of 2018, about a year prior to that, right? Continuing, upon a verdict, this appeal is being made, and judgment was made upon that verdict, convicting that defendant Dunham of the seeming crimes, as found, of sexual abuse in the first degree, of criminal sexual act in the first degree, and of rape in the first degree. Defendant was charged in an indictment with sexual abuse in the first degree, criminal sexual assault in the first degree, and rape in the first degree, arising from him engaging in sexual activity with a victim who was, interestingly, they didn't make a legal determination on this fact, so they state here, you note, she was allegedly unable to consent due to physical helplessness. Very interesting that even in the opinion, and keep this in mind, where we want to make the finding, or where the finding of guilt essentially, properly, and seemingly in the case it's supposed to be, would rest on whether it was actually found to be as a fact, basically, that she was unable to consent. Even after the trial court and this appellate decision supporting, affirming that original trial court, lower court order and decision, finding and verdict, rather, it still uses the word alleged. This is your first little snug hint of what the mind hidden series of thread tugs you're going to start finding here, which connect to the, should be the mind blow. We'll continue tracking this. Let's get this story down. Goes on to state, following a jury trial that happened in 2018, that year prior, that defendant, Dunham, was convicted as charged, thus not found as not guilty of any of the charges seemingly, as described here. Onwards, county court there, that lower court sentenced defendant to concurrent prison terms of 3.5 years for his sexual abuse conviction and 8 years for his criminal sexual act conviction, a consecutive prison term of 8 years for his rape conviction, and post-release supervision on each, that in all merged into a 10-year term. And it offers for us to see Penal Law 7045, probably regarding how all that's properly managed lawfully. And we won't scrutinize that. We'll take it as okay, whatever. And they threw much of the book at him, as that saying goes. Onwards, defendant thereafter appeals, and it already tells you the end result of everything that follows is a description of the facts and a retelling of that story, basically. But it gives you the preview and the spoiler alert, where it here says, we now affirm. That already tells you they sided against Dunham, essentially having him directed back into prison. And where that happens in New York State, mind you, when you lose an appellate finding, basically, there's a little bit of a disadvantage for reasons that I'll go into. So I hope to remember to go into it, but it's important because we're essentially looking to analyze the entire path that a human being goes through in order to see, are they actually getting the fair, in the level of pure substance, that pure realm, are you getting true, real justice? Continuing. It goes on to state, defendant does not dispute that he had a sexual encounter with the victim. He does not argue that the victim was or was not physically, oh no, rather, pardon, that's my misreading. It goes on to state, he does argue that the victim was not physically helpless, actually, as he asserts. Very interesting. Continuing, that this was the case when the encounter occurred. And he finds or argues that the jury's finding, where they found to the contrary, that they found that she was physically helpless, he argues now that jury from the trial court's finding, it was unsupported by what should be legally sufficient proof. Oh, we see then. He's saying that what under the circumstances, he's saying in essence, however you add it up, in fair sanity world, they shouldn't have been thrown into prison for this. And he goes on to state that the jury's finding was also against the weight of the evidence. Serious. Also making reference to Penal Law 130-35 subsections. Okay, and the rest. Onwards. So this is pretty interesting now. Goes on to state. The appellate level court notes for us that physical helplessness generally is present as a condition found applicable and taking place when, quote, this is quoting from the law, a person is unconscious or for any reason is physically actually unable to communicate unwillingness, and we may speculate or figure that means actual unwillingness or potential unwillingness. More we could understand or figure how more of an analysis could be done on that. Goes on to state, unable to communicate that unwillingness to an act. All right? So if someone's sleeping, drunk or passed out, you see. Referencing the various Penal Law 130 and a couple other case law as well. People versus Baptiste and some more. Goes on to state of note, quoting also case law we find interesting, People versus Williams and other spots. Of note, quote, a person who is sleeping is physically helpless for the purposes of consenting to sexual intercourse, particularly where the sleep was drug and alcohol induced. So that's the official legal holding that applies and rides within New York State. We could do a little bit of a commentary on how case law establishes precedent, which is also important. For now, we'll proceed. Let's find out some more. The victim here. She was visiting New York for a wedding and was staying at the home of defendant, of the guy who was charged. She was an out-of-towner coming in. She's going to a wedding, and his romantic partner, Marla Jones, so this defendant was already in a relationship at the time with this Marla. Sure, that doesn't look great. Let's continue. The victim testified, that woman who was allegedly raped, testified to having several drinks on the day, which was before the wedding itself, and after a brief ceremony, several more drinks at the reception. This is incredible. So this is actually supposed to be somebody's best day of their lives. This is a celebration occasion. And it's not her wedding, but they're participating all together, seemingly. We'll get confirmation on that, whether Todd was invited too. I think so, right? We see. Okay. Onwards then. States she realized that she was drunk when she called her husband. Oh, so this victim, she herself also was not only in a relationship, but she's actually married, you see. Aha. So this Todd Dunham is not her husband, and sexual activity took place between him and the wife of the guy. It's an instance of what would be cheating if it weren't a crime. See that? Let's continue. We want true justice on this earth. Remember this, people. So I'm all about this more than you could ever know or believe. Onwards. As we said, she realized she was drunk when she called her husband towards the end of the reception, and her husband testified at the case because, right, whatever happened, then she reported this. This is rape. This is rape. Starting to fill in the spots here of the story. At that trial, the husband's there testifying what? That the victim, his wife, sounded drunk during that conversation when they were talking to each other between husband and wife at the time near the end of the reception of the wedding. Okay, what happens then thereafter? Goes on to state a whiskey shot as she prepared to leave. Quote, and anytime you see a quote, really is typically quoting from the records and like that. A whiskey shot as she prepared to leave really put her over the edge. Yeah, that's how drinking works. She became nauseous and woozy during the ride back to the place that she was staying, which, remember, is the defendant's house with the partner that he's with, which is a last name Jones woman, residence. And she laid down in the back seat of the car on the way. Okay. Upon arriving back at the home after the wedding, and we now find, okay, no mention actually of this guy being at the wedding. I see. Yet, but I read this years ago and I'll need to recall. My memory's not excellent. It has tremendous faults sometimes. Well, let's continue. Upon arriving, so she got back, super drunk still. Okay, we know that deal. We know how that works in life. Goes on to state the victim, the woman, went to the bathroom and knelt over the toilet to vomit. Yeah. Pretty drunk. Good. Her recollection was, quote, very spotty from this point forward. Because she was drunk enough, we may add as a side note that the memory starts to become patchy. But as it further states here, her recollection was very spotty from this point forward. But, right, she recalled the defendant, Dunham, Todd Dunham, reaching under her sweater while she was braced against the toilet and groping her breasts from behind. Okay. We have that part of the story put in. We know that happened. No one argues that it happened. We need to take a closer look at the original trial, at least the trial opinion, wherever we could find it, to see what we're in the process right now of reading together and collecting all the details. But we don't know whether it got from between she entered the house and her breasts are being fondled because he totally threw himself at her inappropriately, or whether, naively to speak so far in the reading, you'll see enough soon, so watch. But we don't know whether it's because she gets in, but something in her is actually, regardless of whether, maybe only because she's drunk, but still she's inviting it. We don't know yet, not so far from what we've read here, but let's see what more we'll find. It goes on to say, then she next remembers waking up in bed to find defendant wetting his fingers in his mouth, inserting them into her vagina, then subjecting her to anal and vaginal sex. And like I said, So far, just from this description, we don't know whether we bridge from that point to that point, because in actual reality, what was happening, if you were God looking in, tracking in, or fly on the wall, that she's going with it, but she can't remember that she went with it, or that she totally was this cold, resistive thing, and he was totally coming in the wrong way, in the worst way, right? Goes on to state, she testified that she had no control over her body. You see, she has no control over her body. She was unable to react. Mm-hmm. Hold on, something else is coming to mind. Let me recall if I could.
He saved your kid, didn't even get a thank you, and now you're suing him? You okay? What the hell is wrong with you?
This poor man saved a baby's life, only to be sued for $500,000.
That was a reckless rescue, and he should take responsibility for the consequences.
The incident happened in Texas. 25-year-old Jason Miller was walking down the street when he saw a baby slip through the railing of a fifth-floor balcony. He rushed forward and managed to catch the child just in time, but the impact was so strong that the baby suffered multiple fractures in both arms and legs, and Jason himself was injured. Despite the pain, Jason held on and called 911, staying with the baby until paramedics arrived. A few days later, the baby's mother filed a lawsuit against him, accusing Jason of reckless rescue.
That was a reckless rescue, and he should take responsibility for the consequences. If it weren't for him, my child would have never been hurt. Is it really wrong to ask for some help with the medical expenses?
He saved your
What's
kid,
really going on,
didn't
huh?
even get a thank you, and now you're suing him? What the hell is wrong with you?
In court, Jason still had bruises on his face.
I think I regret it. I should have never gotten involved. I underestimated how cruel people can be.
The case sparked widespread public outrage.
They decided to sue because they wanted money, not because they cared about saving the kid.
So they're the ones who should be in jail.
After a brief trial, the judge delivered the verdict.
I hereby dismiss your lawsuit and order you to issue a formal apology to this gentleman, as well as pay $30,000 in damages for emotional distress.
I just had to put that out there for just a moment there. Okay, right. I don't know why that came across my mind to do that. Let's come back here. Okay, as we were saying, she has no control over her body. She was unable to react, which was consistent with the testimony, mind you, people, of a physician at that trial who explained for the public so that we can learn and understand. You see, we're told how it's the case that an individual who's in an alcoholic stupor could be awakened by painful or frightening stimuli, but would remain confused and without motor control. Poor people, fuck. God, this world is disgusting. Let's continue reading here. Goes on to state, defendant, then, the guy, Dunham, left the room after sexual intercourse with her. When he was finished, and the following morning, the victim left the residence with Jones, who is the right, the two girls, the girlies, with her and Jones being the girlfriend of the defendant there. They left after disclosing what she described as the morning after. She's describing it as a non-consensual encounter in the electronic messages exchanged between Jones, the victim, and the defendant on that day. Between those three, as they're texting back and forth, the day after they've sobered up. Goes on to state, defendant Dunham, he acknowledged that he had, maybe he was a bit drunk. We'll get the details on that probably, hopefully, likely. He's just writing and acknowledged that he had lost control And he also acknowledged, although this is interesting, that remember, these are the words of the appellate panel, those judges. They themselves are taking ownership of how they're wording it. So I actually find it very interesting that they're wording it here saying they are stating that he, on that day, acknowledged that he had, as it goes on to then stay right there, taken advantage of the victim. Is that reasonably true? We need to know from the trial records, but it's already a little bold that this is asserted like this. Interesting narrative or the way it's being represented. Something in my subtle deal reality detector is going a little interesting here. Let's continue. Also, he apparently acknowledged that, as it further states, he eventually realized that she was, quote, either sleeping or just not interested. I'll add as a side note now. Keeping track of the narrative, okay? We don't know whether she was initially interested and then stopped being interested because she naturally passed out. People, I don't want to start talking about my own life, but listen, a non-negligible proportion, I'll tell you, significant proportion of human beings and human males have lived life and have had experiences not so wildly, boldly dissimilar completely from this kind of thing, okay? A significant proportion of the entire human population has had something that's in the rough, broad ballpark sense of what this is. Yes, everybody knows this. This is why this case is very interesting to read. Goes on to state here in the records, and he also acknowledged, or how is it? How's this word here? It states, and failed to deny her flat. He, at that day after, when sobering up, failed to deny the flat accusation she made that day that he had raped her. See, that's kind of, there's a little bit of a bundle in there. He did deny that he had sex with her. We agree. She poses the non-consensual aspect, and he's there on that day just sort of watching it happen while he is possibly sobering up along with the rest of them, or we'll get a confirmation on that. But okay. And in some senses, this is important they know this, because in some senses, I may comment on that soon. Let me just withhold that for now, but it's a legal kind of thing about how to interpret when people stay silent or don't stay silent or fail to deny like that. Let's continue here. The foregoing proof reflected that proof. Let's see what proof they mean, but let's continue. The foregoing proof reflected that the victim was insensible and unable to consent as a finding of law. And it's interesting they use the word proof instead of evidence. No, it's proof. The astute among you can already start perceiving the slight conflationary human mammal monkey brain errors. Don't just because you put on a black suit, you're still a monkey. I call all the humans monkeys, basically, from my vantage point. Reflected that the victim was insensible and unable to consent. She was unable to consent. Dogma label application. That's the truth. Uh-oh, people, uh-oh. I think some of you get what I'm talking about, and the hair is standing up on the back of your neck going, oh God, this can't really be real, right? This is why the world looks like this, people. Continuing, unable to consent when defendant initiated the sexual encounter. She was unable to consent. Why? Because she was unconscious or merely insensible? Insensible? How insensible? Did he reasonably appraise that insensibility? Did he have the capacity to appraise that insensibility? She herself testified that she didn't remember. Therefore, the lack of memory. You see many, many aspects, and by common sense, you go, yeah. Okay, in late 2025, we have enough of a kind of setting in the world. This might have been hard to make a video on in 2017, 2018, 2019, during the approximate peak of the Me Too movement. Funny how several years later now it's a different world, and we can kind of just it's the right time to start batting this crap down. Finally, striking it down. But interestingly, they cite this case here. I already off the bat, I guarantee you, I've seen this done in many different places across law, scientific journals, all this thing. They just reflexively say, "See People versus Wicks" for the and the other couple cases. I guarantee if you go scan through the entirety of that case, you'll see there might be some kind of misapplication. If you go through this with a fine-tooth comb, you'll find at the capacity, but it's easy. I'll walk you through it. You'll find like 158 different nuances of why this whole thing is actually a false structure. I hate stuff like this. People, stop false thinking. Stop false directing to exert false consequences because you believed yourselves. Why would you do that? And you make big, impressive structures called law. Don't believe yourselves. It still fails you. It's disgusting. Destroy it. Take it down. Continuing, it goes on then to state, then, after all this, she was physically unable to express that unwillingness. We find that as essentially a fact. She was physically unable. It's the God of the law of the circumstance. It's the official narrative we invoke to express her unwillingness to proceed. It further offers compare these cases, People versus Teicher, People versus Kekunjin, Jinin, and onwards and onwards. There then states after. It follows that, as a matter of law, they offer, okay? It thus legally, lawfully would follow that when viewed in the light most favorable to the people, side note, you might, if you don't know exactly a lot about how this all works, you might wonder why is it saying that when viewed in the light most favorable to the people? It has to do with the fact that, but this is also actually, God, I have to get my non-existent team on this, but if I do, you'd see the whole thing. What they're doing here, I would already find, is a false application of a principle, but the principle is that whenever someone makes a motion substantively, or in this case, an appeal, that whoever makes the appeal, the favorable light has to apply to the one who's being challenged, which in this case is the government or the people. You see how that's a little funny? And me saying that there here is not enough, but I want to do a deep legal analysis using some AI things afterwards, and we're going to basically dissect this like crazy. I want that guy rescued, ideally. We need to do something, because this is actually nuts. Because it follows that when viewed in the light most favorable to the people, as per standard in our court culture, the way it's coming along, what we believe we need to do, goes on to state, they find there was, yes, legally sufficient evidence. Oh, now it's evidence, not proof, but here it's evidence. Well, that's slightly better. That the victim was physically helpless indeed. the sufficient evidence that she was physically helpless, legally sufficient evidence that she was unable to consent to any of the charged conduct. Further offers see not only penal law subsection 130, section 30, but also People versus Wilson, yada yada. We might take a look at some of these too. People versus Fuller, and on. Unbelievable. Full stop. Continuing then. At least a significant or even a substantial proportion of those among you in the audience might be going, I could see how at least some people might feel that something might not be perfectly adding up in a fully holistic, common sense way. Let's continue to read, though. Might be too early to judge, but let's see. The victim's account was open to question, of course, during trial, with testimony being made and given from that guy, the defendant himself, testimony being given from that partner of his, the female Jones, and testimony given from all of their friends that she did not appear to be intoxicated at the wedding reception. So probably what we're seeing is they're being good friends. But it's amazing how stories can differ. Now, probably she was heavily intoxicated, you see. We could maybe assume that. Almost. Or probably. Most people would. That really is what I want to say here. She did not appear to be intoxicated at the wedding reception. But pay attention to this, people. The reality of the narrative was that she had been flirting with the defendant throughout the day and the evening of the wedding and reception. And that was on sworn statements offering that as fact, which might not have been disputed. Wow. Therefore, presumptively, that's what happens, which fits by common sense. Then this does make it more troubling. See what's really going on. I'm going to say it real early here. You wake up, you realize you're a married woman, and I just cheated on my husband or participated in something that would be cheating unless it's criminal. Oh, I don't think I remember. Oh, I don't. Now, I'm going to add this very clearly within this body of recording, okay? This is all my opinion. Everything that I'm putting forth is coming from what I'm seeing here and then offering my own opinion. And I'm not reasonably accusing anyone of intentionally engaging in, something that would indicate poor character, anything like this. Because I admit openly I don't know everything, but rather I'll offer commentary on what most or many, for certain people, in their common sense, what many of them would also internally and likely feel as their own opinion too. But really, opinions often can tend, when held in the correct light, towards what the objective reality really is or should be in terms of how something should be held and regarded. And that's ultimately up to you for you to consider. But if we see cause, regardless of everybody else in the story here, if we see that the defendant deserved something different and that he essentially got screwed, better 100 guilty men go free than one innocent man, properly innocent, under proper interpretation of law and substantive justice, under substantive fairness principle, that one should be condemned when he's actually has the right to not be subjected to that crap. Let's continue. It was undisputed that the victim had imbibed, however. Now, see, that's a weird. This is more human mammal monkey stuff again. Mammal folds, mammal brains, limited stuff. Why would you say judges who work at the appellate court? This is not the first error sort of you made in writing here. Speak carefully. It was undisputed that the victim had imbibed. It was disputed, actually. Sworn statements stated that she did not appear to be intoxicated. So that is disputing it. What you mean to say is that the disputations were essentially not given weight due to other evidence appearing overwhelming. It doesn't mean it's undisputed. It just means you figured out what. God, school these people. Continuing. Rather, they correctly feel or find that they figured that it's true that she imbibed. We would all probably agree, yeah. However, and then further, it states that the defendant, Todd, he admitted that he had groped the victim while she was slumped over the toilet to vomit. See how that's framed? As a fact, yeah, it might have been true that there was a physical contact of that nature being made. But look at the implication writing along. Where is that actually the implication? If you could be floating there as a spirit, invisibly watching in that in real God eye lens, what's going on? Bet you the reality was a little different than what is going on here. Continuing. Okay. And it's funny because, again, I'll actually slightly support for a moment, and this might be in a slightly fragmented way, which I tremendously avoid doing. I'm not going to say fragmented, but I'll say that in a paradoxical sense, it's ironically even true that, hey, technically the woman, the victim in this position, we don't, what's her name here? Do we have it? You know, she might have woken up and then participated within a set or series of events where she might not have been grossly twisting very much at all. Do you see? It could have been selective statements that none of which might have been gigantically off base. Do you see? It's true. I don't remember much of last night. It's true. It's true that this. It's true that that. It's true that one can construct a sort of narrative, and it's. You see, the whole is different from the sum of the parts, and the sum of the parts. Ooh, you see what I'm saying? You see, truly, you can't even point at something and go, this specific thing exactly was the wrong turn, and that's bad. You can't. We have no ability really yet, even here, to do that. But the final result of what you see, people in a dysfunctional system, much like with Prisoner's Dilemma or with Multipolar Trap, every person within their self-referential, imperfect, localized frame does what they believe in their localized sense to be the optimized thing at every juncture. And as a result, the entire system and all the participants involved as a whole collectively ends up doing something insane. Okay? That is what I offer to you. Mashiach is here to destroy. That kind of thing. Okay? Probably what ended up happening on that day is that the husband of this alleged victim was slightly better able to sleep at night due to the way that the events of that day happened, as compared to if the events of that day had not been pressed along a certain narrative line and route, where he ends up having to face that occurrence, but without the backing of the narrative of criminality riding along and being ran on. You see? Continuing. goes on then to state defendant's further testimony, Todd, that he had a sexual encounter indeed. But his testimony was that he had a sexual encounter with a conscious person, a willing person. So again, this is to the judges. You wouldn't say victim. You found it to be a victim, but that's based on the fact that she wasn't willing or conscious. So he's saying conscious and willing. You wouldn't use the word victim. You'd swap out and put the word person, because it doesn't make it a victim if she's conscious and willing. It's you have to catch these things. This is this is runaway train type stuff here in the minds. You got to start snagging and tugging at all these false neural networks, intertwangs. We're here to destroy this kind of thing, and we're here to destroy Amaleks and cluster Bs and narcissos. All that's going to be gone. The capacity for that's going to be essentially destroyed mostly too. Entirely. Something like that. But look at the legal finding that this appellate court makes too. That testimony that he had a sexual encounter with a woman that was conscious and willing. And I'm swearing on the record, sworn statement that this is what was seemingly, apparently, or plainly the case. Remember, well, that is a side note, but important. The defendant of a criminal trial has no obligation to testify. Often, the silence of the defendant can be an added value for a number of reasons. But he waived that, thinking, I want to say it because it has to become evidence. Just the fact that I've spoke it, sworn, it becomes you have to consider it as not unreasonable that this is a plausible line. Just the plausibility, by technical definition, gets one, fairly speaking, off. Not here. What happened? We'll continue to assess this. See if was this correct administration of law and justice, or was this a mess? They put their opinion, we'll form ours. But the court here, the appellate court or the trial court, either one or both, find that that testimony of his about that consciousness and willingness of hers, that testimony was undercut by the statements of both he himself, interesting, and the statement of the victim as well the next day because of those texts. So you can imagine kind of all the plausible, we don't have access to the texts themselves, but you can imagine what the text probably look like. And when you're sobering up from being drunk, what's going on and how you're talking and the kind of, that's going on. Because your monkey brain's playing along with the serotonin-induced imposition of false social order, which is you getting screwed. Find our scapegoat. All that's going to be destroyed. Okay? That doesn't reasonably include the necessity that the reality underlying. Do you see what I'm trying to say without me even being able to complete what I'm looking for with my words? I'll figure the words eventually how to say it, and AI is going to help a lot. And furthermore, that the appellate court finds and states that the statements were undercut, but evidence doesn't get undercut to that extent that it's a funny wording, but let's continue. Further, they go on to state anyway, in any event, quote, this presented a, further quote, classic he said, she said credibility determination, unquote, for the jury to resolve, unquote. Couple cases cited. Wait a minute. This is very important, so I'll have to note this. If it is a he said, she said credibility determination, where it remains as that purely, truly, all the way through, the jury cannot then pick anything. If it is he said, she said, therefore you have insufficient power and ability and clarity to determine that it's definitely not the way he said. Which then probably, do you see the problem? You can't prosecute properly speaking on that. We'll write that out further nuanced. I should be taking many sets of notes while I'm doing this, but whatever. I might do the work later. We'll probably do multiple, even a few or several parts on this. But this is one of the most ugliest things I've ever seen. The way I feel. See if my hunch is right. If other people agree with me. If we get the whole world to agree, maybe we could be saving people, which is the whole point of everything we're doing on this earth, in a large sense. Let's further find, quote, the state of the victim's physical helplessness, as a matter of law, at any given moment is largely a question of fact. And after listening to defendant and victim both on the issue of whether she was physically helpless or not, it happens to be that the jury of that trial credited the proof that the victim was physically helpless at all relevant, I guess you could say, phases of the analysis. Again, judges, come on. Relevant times. Sure, I guess. Couple other word things. Okay. Case law, etc. Onwards. Accordingly, it goes on to state, quote, although a different verdict would not have been unreasonable, therefore not guilty. Is this the Oh God, help these people. Help these people. By the way, a different verdict would not have been unreasonable. Let me state this in a different set of words. I'm not tremendously off base here. In other words, although the different verdict would not be beyond a reasonable doubt, they still found as beyond a reasonable doubt. This is quantum logic. It goes on to for the number of principles that they're tacitly invoking when they state the rest of this sentence that we're reading here. This appellate court states that we accord deference nevertheless to the jury's determination, even though but think you see the hunches, and I'll need to word it out and express it, have AI parse it with me, and have all you watch it. Then suddenly people go, oh God, well, this Winslow guy recording this seems to be getting at it. Why no one else did it? Why did their lawyers do it? Why didn't the court do it? You're all blind. You'll go along with whatever your brainwashing makes you do. Because you're not actually bringing God's line down on earth. I don't know what this is supposed to be. This is disgusting. It could have been any one of you people, any one of us in Todd's position. Do you understand? Fully realistically, what the hell? You get it. Now, continuing, and it wouldn't have been the one in our position, your position, Todd's position, actually was really truly doing the real mega substantively wrong thing at all, deserve to the level deserving this substantive condemnation with 10 plus years. Oh my God. As we're reading, we accord deference to the jury's determination that the victim's testimony was more credible than that of defendant. More credible doesn't mean that the testimony of the defendant was incredible. And you can only find against him if you find what he already offered as sworn statements, which would constitute, fairly speaking, evidence. Basically speaking, right? And in the sense that I mean to put it, you get what I mean. This is law. And mind you, I'm not reading this like I don't know what I'm talking about. I had a, without going into self-embellishing, just know that I know what I'm talking about better than you would believe. Continuing. Conclude that the weight of the evidence further, we conclude that supports the verdict that the jury originally made in the trial level at the lower court. While citing all of these, I bet you already I could see, like if we come in as like God, so to speak, or like as like a King Solomon, so to speak, over this and just start pulling it apart, I bet you we could pull it apart better that once we're done through pulling it apart, you will not build it back up to the way these judges determine in these two levels of courts here. Okay? Once I get through this, you will have nothing to say. With AI's help, as my AI will be my viceroy and declarer of the finding of my court. You've brought this before me that my eyes found this in my world. This is under my jurisdiction. Continuing. Turning now to the defendant's evidentiary arguments. Everything he said to try to make the case as to why it's at least beyond a reasonable doubt. That lower county court at the trial level properly, as appellate court here finds, did allow testimony regarding statements that the victim did make, okay, about the sexual encounter made to her husband and to a sexual assault nurse examiner. Sure. Hubby, it was rape. I'm at a hospital now. That's what we're doing. Hey, everybody, it's rape. Okay. Hey, and remember, the New York state law officially says that whenever you state something in a medical record, that has the non-hearsay exceptionary rule. Why? Because a judge once said, anybody who lied to his doctor is a fool. Therefore, it magically overrides. I see 500 things I can start pulling apart, which in conjunction, my AI is gonna have because AI will understand every part I'm pointing out. It will converge on the same things. Once it agrees with me, it's gonna destroy as an extension of me. Which you will be watching it do its thing. Continuing. The testimony of the victim's husband as to what she told him about the incident as soon as when he picked her up at the airport. Oh! Of course he wasn't there. Now it all starts to become clear. What the hell? As we find, by our opinion and sensibility as it's set, I think we're all disgusted, many of us, by now. Why are his hands on me? He's groping me. Okay. Again, it's technically it's not unreasonable to characterize it as groping. See? But onwards. It goes on to state that this served the non-hearsay. Let's find out whether this makes sense. Also, I don't trust this appellate panel already. I'm not going to officially call their competency into question as a fact that they're definitely not where they should be as judges. I'll just say as my opinion. And I'm not a professional, and they're professionals, but whatever. We'll see what AI says. AI is not human, so magically it's immune from, it could say whatever it wants. What more? Let's see. The appellate court now says or finds that there's a non-hearsay purpose of explaining why he urged her to call the police. I'd be interested on a little bit of elaboration. It's not an excited utterance exactly, but on the other hand, it's an extended sense of mobilizing to report roughly as soon as possible, which can be within the course of a day following something like this by the various standards, and it's not a precise science; it's an art, almost with that. But continuing, context, everybody. But whatever. I don't see enough of an explanation. So again, these judges are getting lazier and lazier, and I'm not just saying that. I've read case law from the 1920s, 30s, 40s, 50s, 60s, hundreds and hundreds and hundreds of cases. Fun as a hobby, because this is where I'm being brought through. I've seen decade over decade, judges went from being masterful analyzers of the true thing with a much better capability to discern true fairness in law, judgment, reality, beautifully, right? And probably since after 1980, 1990, it started getting slightly twangy. Right after around 2000s, accelerated like a rocket ship to insanity. And everyone's like, from my perspective, it's like judges are inserting LSD syringes into their brain cortex, all of them together, before they show up and they start writing all this cereal soup stuff. It's unbelievable to me. What happened, humanity? Just because it's everything that's affecting everybody, all of us on Earth. Onwards. Okay, so when you put people's fate into the hands of systems like this, I'll say system overall, okay? The system, this is what you get. A mess. Stop this, people. You're killing each other. What are you doing? Judges, you should explain why it's non-hearsay purpose, but maybe we'll take a look at the various things here if we get a chance. Okay, further explains that county court then gave an appropriate limiting instruction to the jury, whatever that was. Maybe you want to tell us? No. Seemingly. Okay, next. The sexual assault nurse examiner then was also free to relate the victim's statements about the sexual encounter as they were germane to the nurse's diagnosis and treatment. Somebody, okay, let's just go with it. Whatever. I know. And an appropriate limiting instruction was given, whatever it was. Okay. Next, as for Jones's testimony, the guy's girlfriend. During the people's case in chief, it states, quote, county court properly exercised its discretion in permitting the prosecutor to ask leading questions of the prosecution's own witness, inasmuch as Jones was the defendant's long-term romantic partner. Her testimony differed from what she had previously told the prosecutor, okay, about the incident. And what differed? I hope you tell us. Might not happen, but we'll see. From what she had previously told the prosecutor about the incident, and county court noted her recalcitrant demeanor on the stand. Yeah, I'm recalcitrant. Anybody beholding such a sick fucking railroading job would feel the same way. It's my opinion that it seems to be one. Basically. There could be. Rather, truly. At least some sense. Onwards. Further notes various things. Some of the I can almost promise you that probably it could be argued how some of these case references might be at least slightly out of context. Might be crap. Excuse me. No. Further goes on to state. Afterwards, that's full stop now. Again, we're left in want of something. Okay, never mind that. Defendant also contends that the people who found against him by adversarial verdict, that the people, the jury, or the court, improperly elicited testimony from the victim regarding her mourning after disclosure of the sexual encounter with defendant to Jones. Jones had already testified about the conversation without objection. However, Jones's account was less detailed, but not radically different from that of the victim. Okay, so first, prior you said that the testimony differed, but here accounts are not radically differing. So that's the job of the writers of this, to tell us a little bit more, at least. Come on. Onwards. And the conversation explained the actions of the two women and defendant as that day after did unfold. The appellate court then states and notes, there was then as a result as they lawfully here now find, nothing inappropriate in that lower trial court allowing the victim, the lady, to provide her version of it. See various things. You know what? My hunch is I could find some interesting things, but we'll see. What else? Next. Defendant, but that's not what my thing rests on. And the core of what my thing rests on will be the core of what should and would properly dismantle it in the eyes of many, I believe, if the world were to turn and affix their attention, your attention on this. This guy's still sitting in jail. Do we have justice in how New York sets its laws legislatively and then also runs them in the judiciary? Let's continue. Next, defendant complains of the expert testimony of the physician, Ike Blome, regarding the effects of intoxication. So, as a side note, to clarify, during the process of the trial, there's the ability for both the sides that are contending or arguing, basically, to get their own expert. And conveniently, even though there's one truth, each side's expert provides the expert level testimony that always is going to match what that side is advocating for. So it's this weird ritual where you get, it's kind of unbelievable, and you get these. That's why this whole system is going to be broken down soon, we hope. At least some figurative or substantive level or whatever, essentially. At least. Indifference in justice is the gate to hell, people, and remember that. That's a quote affixed to the actual appellate division, not the third department, but the ironies are incredible. Let us not have that indifference. Let's see onwards here. So there's this ritual where each side, hey, they're both doctors, so really the experts are supposed to be smarter than the lay people, which is why we employ the experts. And it's the two experts warring against each other. So even the experts can't agree. And necessarily within the context, they'll never agree. So, and then weird ritual. And then we have to sit and go, which expert was more convincing? Oh my God. And that's not how it's supposed to work. But regardless, so the one side's expert that was brought in, do you see? This Blome, he comes in from that side and he says, okay, I'm the expert. I'm going to explain for everybody today the effects of intoxication. As if the people don't know. The people alleged that the victim's intoxication is what contributed to what was found as a finding of, I don't know what to say, law or fact, but her physical helplessness at the time of the said that she's pounding drinks into herself while flirting with the guy. And my husband's gonna get me at the airport tomorrow. I'm here. This is great. I'm staying at your place and whatever. Uh, not an unreasonable characterization of the events. That you see. Okay. Uh, Physical helplessness at the time of the encounter with the defendant. Okay, then that Dr. Blome, our expert, specifically explained the phases of intoxication. Oh, including the stupor phase of intoxication. Totally not responsible. She's in the stupor. What happened? And the physiological effects associated with each phase. Oh, now we understand. Condemned, guilty. County court, you see what I'm saying? County court had every, quote, every reason to suppose that such testimony would elucidate some material aspect of the case that would otherwise resist comprehension. Are you sure? In 2018, they're speaking this naively by jurors. Comprehension would resist comprehension by jurors. Onwards as we read of ordinary training and intelligence. We don't know what a drunken stupor is, and did not abuse its discretion. Therefore, this court finds now the appellate panel in placing the testimony before that jury. Good thing the jury heard what the stupors do. What are you people doing to each other? Continuing. My God. As a side note, people are saying some interesting things that have been for the past year plus. There were things said and have been things said about me, your narrator here. People, if I am a Messiah, this would be my first messianic mission in this world. Free this guy. Bring true justice and show what real justice actually looks like. Mind you, we're only doing the reading now. We haven't done the AI analysis, but we'll do it. And it's going to pay to do the best one possible. So I'm going to have to do the best one that we can do. Given my things, I also live with brain damage and things like this, as I put forth here. And it is true, as I tell you. And you'll, oh, God willing, you'll see evidence of this soon. We're trying to work on some things. But hey, not bad for brain damage, right? What an interesting story. Continuing. For now, appellate court tells us, though, as we see, that, contrary to the defendant guy Todd Dunham's further contention that he made, the jury actually was properly charged as to what the definition of physically helpless means in the law. We define it. And then, well, actually, the legislature defines it, and then realistically, the judiciary and through case law can actually warp it up quite a bit in interpretation. But that's an offered thing, and let's just see how true that may be. Continues to state, county court, they tell us, administered a charge on that issue that closely tracked the criminal jury instructions, but added language that a person who is sleeping in life, we're going to tell this jury how to do their job, you see, we're going to tell you that by our law, by our culture and framework of what's going on here, to very basically put, a person who is sleeping, will have you know, is physically helpless. for the purposes of consenting to sexual contact, particularly where the sleep was drug and alcohol induced. This charge, when viewed as a whole, quote, conveyed that it was for the jury to decide whether the victim's state of being asleep, within the actual real life circumstance of that case was about, did constitute the true lawful criteria matching of legal physical helplessness that is required, as is required, and more reference to the case law, People versus Scene. Then goes on to state, defendant also contends that he did not receive the effective assistance of counsel. Wow. Because his trial counsel, his lawyers, his attorneys, advocates, did not raise the affirmative defense that defendant, Todd Dunham, was unaware of the facts and unaware of the conditions that were responsible for the victim's incapacity. People, hey, everybody, how many of you were out and living in the world and life and doing all the things? Hey, a significant proportion of all humanity. How many of us have been in the position where you're dealing with somebody and at the time you genuinely didn't appreciate fully how truly drunk or messed up they were until after the fact? And then in recovery and hindsight analysis, it's like, oh, I don't remember anything. And it was that bad? No one could tell while we were doing anything through the thing. Whatever the event is, whatever's going on in the day, in the narrative story of what's happening. These people are getting messed up, right? Interesting. So this fact that he was unaware, I believe him, actually. I believe him. He probably wasn't sitting there. Realistically, everybody, I don't think most people would disagree or even bother arguing strongly against what may be offered here, that really, in a real situation as it was unfolding moment to moment, the guy wasn't standing there going, even crossing his mind that right now she is so messed up that she isn't gonna have memory later about this moment now. I guarantee you. In fact, if it did cross his mind, he probably likely would have stopped. Although, likely, but not. Continuing. So this fact, is what we were saying, wasn't brought into the court for the jury to consider. Jury, you naturally would have had the brains, there's 12 of you, to invoke this consideration as plausible. It's latent and inherent in the circumstance, actually, basically or essentially. And you could formally raise it, swear on it and all that. What do you mean? Wait a minute. The counsel didn't raise that as an issue, fact, or make an affirmative defense formally about that? Thus, it's not effective assistance of counsel. Hey, in some sense, that sort of makes sense, doesn't it? Oh my God. What the hell is going on here? People, 10 plus years or 16 years, I've seen different numbers here and there. He's sitting in jail from this far back. He's not even halfway through or barely close to halfway through or more or whatever it is. Oh my God. This is disgusting. He was unaware of the facts or conditions responsible for the victims as found by the legal system incapacity, quote unquote. God help us. Goes on to state further, his theory of the case, however, was that the victim had not had much to drink. Yeah, which, if the reality of how much he had to drink. People, at the wedding that she was at, which still it's not clear whether he was at that same wedding, but seemingly not, it would appear by now. Okay? Oh, so that actually supports that he really wouldn't be able to appreciate it. So that helps him. But then let's see what these are grown men in this panel, and they're thinking, arguing like that. What the hell's happening here? His theory of the case, however, was that the victim had not, because you see what they'll do, had not had much to drink, that she wasn't incapacitated, and was a willing and active participant in the sexual encounter. Yeah, indeed, it would have appeared to him and probably a lot of guys in his position. What are you doing? Onwards. The affirmative defense, we speculate. Speculate. Okay? Would demand, but speculate. Genuinely, it is an element of significant speculation. Maybe bordering on negligible, but hey. The affirmative defense would demand proof of the victim's intoxication, you see, that would have undercut the defendant's own testimony regarding her conduct earlier in the day. This is monkey logic. Oh my God, this is really disgusting. Wait till AI gets a load of this. It's going to tear these people apart. Okay? You don't know how to conduct justice and make judgment on this earth. This is going to be the flagrant, flaming, at your front. This is going to be the leading example in the messianic realm of what the hell bullshit looks like. How to fuck up. Wow. This is abhorrent to God, abhorrent to Hashem. So take a close look, reread that for yourselves, and understand the monkey logic that they're putting in. It's interesting and nuanced, and this is going to be a great spot to have the AI really word it so well, because here is where AI is going to excel tremendously. You'll see. For now, it continues. They state to us in figure, it is incumbent upon the defendant to, quote, we're going to cite that magic holy law, demonstrate the absence of strategic or other legitimate explanations for counsel's allegedly deficient conduct. Sure. Citing cases, also see other cases, onwards. And then it states, and it was sensible, further states here, to avoid presenting an inconsistent defense that would, quote, create a risk of juror confusion and may well have tainted defendant's credibility in the eyes of the jury, yet not really. What are you people doing? Everything is backwards and inverted if your eyes are crossed. If your brain wires behind your eyes are crossed, even if your eyes look straight, which is what we're dealing with a lot with cluster B land. And all of you, these craps. Continuing. Citing more cases, People versus Bradley, etc., quoting other cases. I bet, and we could do the chains and just destroy it all. We'll destroy it in 500 different ways. Each of them, on its own, one way, would be sufficient destruction. It's like destroying you 500 times over in different ways, each of them fully valid if it were only that. Sure, beating a dead horse, it will be how I would be with this. Onwards. They find his remaining claim of ineffective assistance involves matters outside the record. What? Tells us something. Oh, people are supposed to provide a full scope of the information for the purpose of publishing this court opinion? What are you doing? That is better explored in the context of a CPL Article 440 motion. Yeah, I don't like these guys, but maybe you like them. I don't know why. Help us understand. Onwards. Finally, county court lawfully directed that the sentence for the conviction of rape in the first degree run consecutively to the others imposed because the convictions arose from separate and distinct acts, notwithstanding that they occurred in the course of a continuous incident. Oh boy, oh boy. See that? So, in the course of what happened, you moved in a finger, there it is. And through what you're doing, you're switching places. Here's a finger, here's a dick, here's a finger, here's a penis. Oh, that's different. These are different, distinct acts. Fucking hell. That you know what a difference that is? Take away from your life? That's the added together versus next to each other, served simultaneously in parallel. Several years of added. Oh, God. Horrible. But we'll see if this is right. People versus Soto. On and on and on. We're gonna. I personally want to come in and destroy this. Substantive. In the inner Chassidus and the inner Panemius, it must be integris or it's nothing. It must be wiped away and scorched. Do a God job on this. Let's do it. Quoting, citing the various cases, full stop, then proceeding on. It states then, in view of the conduct for which the defendant was convicted, and in view of his failure, wow, to accept responsibility for it. That's disgusting of the court to put that in there. Oh, he didn't take responsibility, bad man. Quote, we find no abuse of discretion, nor do we find extraordinary circumstances which would warrant the modification of the sentence. Quoting the law. Ugh. Others concur. And actually, this is very important because when you have one and then a second Egan Jr., a third JP. No. Pardon. A first Egan Jr., a second Aarons, and a third Rumsey. Thought there's supposed to be 5 of you. What's going on here? I'm sure someone will have something to offer me. Okay, continuing. Order that the judgment is affirmed. But the thing to note is that no one disagreed here. Now, when someone disagrees, this in the law enables in New York a route to be able to make appeal to the next highest level, which is the appellate court over the highest one. And I forgot the name. I don't know why I would forget that name. Because there's 3 levels. Trial court, this is the middle one, which is the first of 2 appellate levels, and then the highest of the 3 is the capstone top appellate over all of New York, which is the final highest, the Supreme Court, so to speak, of the appellate, but though ironically New York, the bottom court, for some reason, is called Supreme Court. Remember, in reality, you invert everything, and we call that sense. So you get signs of that everywhere. It's meant to, play with your mind a little bit in this matrix. So, order that the judgment is affirmed. The problem in New York law is that if all of the judges agree and concur, as shown at that middle second level, which is at the first appeal at the appellate division here, you don't have an automatic right to just continue appealing. What? These guys essentially become your final determiners. That doesn't happen in all states. And I don't think, and federally it's not. This is wait a minute. Have you cut off? So if someone, But the reason you have 3 level, and guess what? This is installed from the legislative. This is not a judiciary error. This is legislative law establishing and setting that it must be this way. Oh, legislature also might be, at least arguably, conceivably, guilty of blocking true substantive justice line. Anything that contributes to permitting what is actually something horrendous and bullshit because it's following the system the way the system, everybody that's contributed to how it is karmically, essentially, resonantly guilty. They further end here and state order that the judgment is affirmed and matter remitted to the County Court of Essex County for further proceedings pursuant to CPL 406050. Okay. Well, this has covered it. If I could find that County Court of Essex County original opinion and also add it so we could have its covering and its opinion, and I think I came across it once years ago. If I didn't save it somewhere, my computers are broken, damaged. I don't know where the files are. Everything's crap. And then I'm searching now, and then the websites that had it are offline now. It's all, you can't make this stuff up. We would want that, and then we want to feed everything to AI and start training the AI or prompting it to become the legal master. We're going to ask it Socratic method questions. We're going to have a AI panel. We want to take in, if we get a chance to, maybe comments and other things from people. Possibly put this somewhere. I'm considering the possibility of putting this on a Reddit place somewhere, the law subreddit, and like that. But but for now, we find that it may not be unreasonable for some people, at least, to find, wait a minute, in our intuitive sense, it's almost obvious that maybe we shouldn't believe that this is totally right. See that?